into a trust. Oh, sounds like we just started recording here. Okay, so types of special needs trusts. If you're going to put money into a trust or have somebody designate that trust as a beneficiary, we want to make sure it's the right type of special needs trust. So, number one is a first party special needs trust. And this is a trust that is funded with the assets of the individual who has special needs. To set this up, the beneficiary must be under the age of 65 and there is a payback requirement. So, as an example, let's say your child who has special needs accidentally winds up with a chunk of money. Maybe grandma named him as a beneficiary of a $50,000 life insurance policy trying to help out. But now he's in a situation where he's going to lose his benefits if he takes that money. So, what he can do is he or his guardian, provided his guardian is authorized to do that if he has one, or his agent under a financial power of attorney, depending on what type of setup we have, that money can be placed into a first party special needs trust. It's his money, right? It's not someone else's. He was the direct beneficiary. And that way we can preserve his benefits. But if he dies, there's a payback provision with all first party special needs trusts, meaning whatever the government had been paying to provide for his care, the money on his death is going to go back to the government as payback. And that is compared to a third party special needs trust, which is a type of special needs trust that's funded with the assets of another individual or multiple individuals. So, for example, if you create a third party special needs trust for your child who has special needs, you created it and you put your own money in there. Or if it's a type of trust that springs into existence after you're gone and it's funded with your own assets, not the individual with special needs, not their assets, but your own assets, then it's a third party. There are no age limits, there's no payback requirement. And so then if something happens to that beneficiary, you designate where that money goes, maybe back to other children, maybe to another family member, to charities, but you have full control over that. And then there's a pooled special needs trust. It's managed by a nonprofit association such as WISPACT. WISPACT is one of those organizations in Wisconsin that is pretty well known. So, for example, if you have, let's say you have the child with special needs and he comes into $10,000. We don't really need a standalone first party special needs trust with a separate taxpayer ID number. Instead, maybe we want to put it into a WISPACT account. And that way you don't have to worry about filing the tax returns. You don't have to worry about investing. You can be the advisor on the account. So when your child with special needs something, a new laptop, an iPad, summer camp, martial arts classes, whatever it is, then you request that, and the money is paid directly to the organization providing those services. This type of a trust must be established by the parent or the grandparent or guardian court or by the person with a disability, provided they're able to sign legal documents. No age limits, and the payback requirement, even with a pooled special needs trust, depends on whether it was funded with the individual with disabilities assets or with a third party's assets. So the same rules apply there with regard to the payback requirement. So now let's talk about wills, what they do and what they don't do. So what a will does is, number one, it names a guardian for any minor children, or you can also designate your preference for successor guardians in the event something happens to you and you are the guardian of your child with special needs who may be an adult. It's the only place you can name a guardian in Wisconsin is in a will. It also designates who your personal representative is when you're gone, also known as an executor. In Wisconsin, we call it a personal representative. And your will establishes how the assets in your estate will be distributed upon your death. Now, a will can include what we call a testamentary special needs trust. So a testamentary special needs trust is a type of trust that springs into existence after you're gone through the will. Now, it does not avoid probate, which we'll talk about in just a moment, but you certainly can establish a trust within a will. What it doesn't do is, if you just have a will, it does nothing if you become mentally incapacitated, which is why we need those power of attorney documents that we talked about earlier. And a will does not avoid a death probate process when you're gone. So what is death probate? Well, if you die with assets that are titled solely in your name, and they don't have a beneficiary designated, and the total value of those assets exceeds $50,000, which is easy to do, then your estate now has to go through the death probate process to get to the beneficiaries or to the trusts that you've named in the will, right, to receive your estate. Um, Now, it's a court proceeding, and so I'll just say whenever we're in court, nothing happens quickly, cheaply, or privately. It's simply the nature of the beast. On average, probate lasts about a year in Wisconsin, even a simple probate, and it's just because we have a lot of paperwork to get through. We have a lot of documents to file. We have to publish notices in the newspaper, giving your creditors 3 months to come file a claim against the estate. And then for the pleasure of using the court process, the courts charge us $2 per thousand based on the value of assets going through the probate process, which doesn't include attorney's fees, which are going to be in the thousands. It doesn't include the publication expenses, so it's expensive. But then I think one of the main issues is that it's public. Right. So anybody could type in your child's name, go online, see the value of the estate, names, addresses, who's in charge of the money. Anybody could go down to the courthouse and get a full copy of the will to see the terms of any trust you set up for children with disabilities or for minor children or, pseudo-adult children. So it's not ideal. And for those reasons, many people consider other estate planning alternatives. And one other thing I want to mention about probate is, let's say that you have an adult child who you disinherited for whatever reason. Life happens. If your estate has to go through probate, then that child is legally required to receive a copy of your will showing they've been disinherited and an invitation to probate court to come object to it. So various things to consider when we're looking at the probate process. So how does it wind up in probate? Well, as I mentioned, if you die with an asset titled solely in your name, or if you've named your estate as the beneficiary, then those assets have to go through probate. So you can avoid probate in a number of ways. One is through joint tenancy. So joint tenancy is where you own property jointly with another individual or individuals. So if you're a married couple, as we talked about earlier, if you have both names on the deed titled as joint tenants or survivorship marital property, on the first death, that property is simply going to transfer to the spouse, right? No probate. Similarly, if you own property with someone other than your spouse, so let's say it's pretty common in Wisconsin, parents die, they have the cabin up north, right? And now after their estate is settled, you have three siblings owning that cabin up north together, right? If you're in that situation, take a look at the deed because the deed is very important to determine what happens when you die. If it has the name of, Larry, Sally, and David as joint tenants on the deed, those words as joint tenants, when one sibling dies, then that sibling's one third is going to pass outside of probate to the other two siblings. And that's compared to tenancy in common. So if you have a deed that has all three names and it's silent, it doesn't say anything, right? Or if it says as tenants in common, then when you die, your one third interest in that property is going to go through probate and it will be distributed to whoever you've designated. Or if you don't have a will, if you have nothing, to your heirs at law, which means to your spouse if you're married and if you share all children with your spouse. If you're a blended family, spouse keeps his or her marital share and the rest goes to your children. If you're not married, everything goes to your children. If you don't have any children, then we go to parents. If your parents are gone, we go to siblings. If a sibling has died, nieces and nephews, and you find your closest living blood relatives. But you can see how that could get very messy, especially when you have three names on a deed with no specifics there. Another way to avoid probate is through a payable on death designation. So, for example, if you have a bank account, you can very easily go meet with a personal banker and say, I'd like to add a payable on death designation to this account, known as a POD. And so what that means is whoever you've named as a POD beneficiary on that account, when you die, all they need to do is to take your death certificate to the bank, and then that account will be cashed out. They'll write a check to the designated beneficiary. No probate. Now be careful with that. So sometimes what I see is parents will name one child as the POD beneficiary on their primary bank account with the understanding that that child is going to use that money to pay for their final expenses. that child who's a POD beneficiary is under no legal obligation to use that money to pay for mom's final expenses. He or she can pocket the money, say, look, I'm the one who was helping mom pay her bills in the end. This is my money. Now let's all figure out how we're going to pay for mom's funeral. So just be very careful with that. It's one of my I have a brochure, Avoid the Top 10 Mistakes Made with Beneficiary Designations. That's definitely on the top. Similar to POD is transfer on death. And so this would typically apply to something like a brokerage account, something with stocks and bonds. So with a transfer on death designation, instead of cashing out the stocks and bonds, everything is simply transferred in kind upon your death to the designated beneficiary or beneficiaries. And then, of course, the most common types of beneficiaries that we think about are beneficiaries on retirement plans and on life insurance policies. Again, no probate there. It passes directly to the named beneficiary. One other thing with these beneficiaries I want to mention is sometimes I find spouses will name each other as beneficiaries, but there's no contingent beneficiary. And so if your spouse dies before you and you never update the designation, then we're back to square one and the account goes through probate anyway. Now, it sounds good, right? Let's avoid probate. Let's name direct beneficiaries on all of our assets. But you have to be very, very careful, especially if you have a child with special needs. You cannot name your child with special needs as a direct beneficiary of anything. Because what happens, as many of you probably are aware, in order to qualify for SSI, for example, you can't have more than $2,000 in assets at any given time, right? So now that beneficiary is in a position, they might get disqualified from all the benefits they're receiving because they have too many assets. And then they have to maybe spend that money down and then reapply for the SSI, Medicaid, other benefits, which hope they get approved the second time around. They do have the option, if we act quickly, of putting that money into a first party special needs trust, maybe a WISPAC trust as a stopgap measure. But again, now we're in the realm of first party trust. And if something happens to that beneficiary, the money's going to go back to the state because there's that payback provision. So that's not ideal either. Also, you never want to name a minor child as a direct beneficiary of anything. If you do that, then what'll happen, let's say you name so I have a 13-year-old. Let's say I named my 13-year-old as a beneficiary of a life insurance policy. Well, she's not legally authorized to sign any documents. And so now somebody, even her parent, even her dad, might have to go to court, would have to go to court and get appointed as the guardian of his daughter's estate in order to claim those proceeds. And then the court is going to put that money into a locked account. Anytime the guardian of the child needs money, they have to request a court hearing, explain to the judge what the money is for, and hope that the court will release some of the funds. And then the best part is when my 13-year-old reaches age 18, she gets to go in and cash out that account and buy the shiny red sports car with no strings attached. So again, you can't name minors as direct beneficiaries. Sometimes there are beneficiaries who, for other reasons, can't really receive an outright distribution. So for example, I've had clients who have children, they're not disabled, they're not on SSI yet, but they have major health issues that keep coming up and they're afraid that they're going to wind up bankrupt someday due to medical bills, right? And if you name them as a direct beneficiary, there's no creditor protection, there's no protection at all, and it might be gone in bankruptcy court. So again, you just have to be very careful. And especially again, if you have a child with special needs, simply a name on a form is not going to accomplish your objectives. All right, and now I want to briefly touch on future marriages. So I'm not talking about your future marriage or your child's future marriage. I'm talking about your spouse's future marriage if you die first. And so something that I see happen all the time are what I call I love you wills, right? So let's say you're not a blended family, you're a traditional family, happily married, no problem. You have a will that says when I die, everything goes to my spouse, and when we're both gone, goes to our kids. Maybe there's a special needs trust in there, right? Sounds great. So you die, everything passes to your spouse through beneficiaries and joint ownership, right? Joint names on the deed to the house. Spouse is the beneficiary of life insurance, retirement, both names on bank accounts, investment accounts. Okay, so now your spouse has everything. Your spouse gets remarried someday, maybe. And what happens is over the years, that new spouse becomes the joint owner of the home. the beneficiary of the life insurance policies, the retirement accounts, the bank accounts, right? And now your spouse dies, everything goes to the new spouse who can disinherit all of your children. There's nothing I can do for a disinherited stepchild. And so it's at least something to be aware of. I tell my husband regularly when we're talking about estate planning, it's not that I don't trust you, but I don't trust your future wife if you get remarried after I die, right? So again, something to at least consider. So, how do we avoid death probate? Well, number one, you can name direct beneficiaries on all of your assets. And we talked about the pitfalls of that, particularly when we have special needs involved. Or another way to stay out of probate is to create a fully funded, revocable living trust. So I know that putting your assets in a trust, sometimes that sounds a little scary, but it's not scary at all. And the reason is because when we're talking about a revocable living trust, you are the grantor, so which is the creator. You're also the trustee of your own trust. You're also the beneficiary of your own trust during your lifetime. So because you occupy all three roles, you're not giving up any control over your own assets with a revocable living trust. Now, before we go to the next slide, I do want to briefly compare that to an irrevocable trust because a lot of people have questions about irrevocable trusts. So for the vast majority of people, a revocable living trust is probably going to be your best option if we're looking at trust-based planning. But there are two ends of the spectrum where you may have an irrevocable trust that it might be a good idea. So one end of the spectrum is where maybe you have a widow and all she owns is her house. She owns it outright. She's lived there for 40 years. She raised her family there. It's paid off. And she's living on Social Security. She knows that if she has to go to a nursing home someday, she's going to have to go on Medicaid, right? And so what we can do is we can take that home and put into an irrevocable Medicaid asset protection trust. She can't be the trustee of the trust. She is truly giving up control over her primary assets. So her kid or somebody else would need to be the trustee. She can live there for her lifetime without paying rent. But if we make it past a 5-year look back period from the time we create the trust and transfer the home into the trust, if she has to go to a nursing home after that, the house is a non-countable asset and she can go on Medicaid right away. And the house, when she dies, still is going to be able to pass to her kids. So that's one irrevocable trust that people may use. The other end is, let's say you're worth more than $15 million. So you're taxable and the benefits, the death benefit of your life insurance policy, as I mentioned, it's included as part of your estate. So if you're over that exemption amount, now your life insurance proceeds are going to get taxed at 40% because that's the federal rate. And now we need to take that life insurance and put it into an irrevocable life insurance trust to take that money out of the estate. But you can see how for again, the vast majority of people, it's the revocable living trust that is the best option where you maintain full control over your assets during your lifetime. So the slide that I have right now, it's just an example. It's a hypothetical couple, David and Susan Smith. So let's say they created a living trust. And so we build the box, we create the trust, and then we transfer all the assets into the trust. And this is really important because if the trust isn't funded, if we don't have everything properly tied to the trust, we're not going to avoid probate, which is the whole point, right? So we build the trust, we transfer all real estate into the name of your trust. So certainly your home. And I have plenty of clients who own multiple properties, some out-of-state properties. I have some snowbirds. And the thing about that is if you own real estate in any state other than Wisconsin, if you don't have a trust and you don't have your properties in the name of the trust, you're going to have multiple probate proceedings, a separate court proceeding in every single state in which you own real estate. But if you have a Wisconsin trust, you can put all your properties, including out-of-state properties, into the name of the trust, right? So we draft the deed, you sign the deed, we record the deed. We want to make sure that your life insurance designates your trust as the beneficiary. We want to assign all personal property to your trust. Future vehicles might be purchased in the name of the trust. We want to make sure all of your bank accounts are assigned to the trust. Now, checks don't change, account numbers don't change. It doesn't affect direct deposits or withdrawals or anything like that. I wouldn't do that to you. The only difference is that the statements show that the account is owned by a trust instead of by you individually. So it's really just something that's happening in the background. For any non-retirement investment accounts, we also want to work with your financial advisors to make sure, or whatever, if you're self-managed through Vanguard or Fidelity, we want to make sure those accounts get transferred to the trust. Retirement is a little bit different. So any tax deferred accounts, right, whether it's an IRA, 401k, 403b, most annuities, those are held in your individual names for income tax reasons. So those don't change title. If you're married, we want to make sure your spouse is almost always the primary beneficiary for income tax reasons. And then if you have a child with special needs, we definitely want to designate your trust as the contingent beneficiary after your spouse. So retirement is tricky, and we just have to make sure that the beneficiaries are properly designated for those accounts as well, depending on your circumstances. So they're definitely part of the puzzle. They just don't get there until the second death, or if you're not married, of course, on your death. So we build the trust, we put everything in the trust. David and Susan are the trustees. Either spouse can sign on behalf of the trust. So if you have one spouse who's maybe having a procedure done or out of town, the spouse at home can easily just take care of everything financial at home. And so now one spouse dies. So David passes away. And this is where we have an option. It's not every trust does this, but some do, of separating it into two separate shares. So think of the survivor's trust as the survivor's share of the property, and the credit shelter trust as the deceased spouse's share of the property. Now, again, sometimes we don't have that green box. We don't have that credit shelter trust. On the first death, everything can simply flow through to the survivor's trust. It keeps the same name, same date as the original trust. We don't even have to retitle anything, which is very nice for the surviving spouse. He or she can focus on the more important things. I always provide a free appointment to the survivor at the first death. And so often the spouse says, that's it. Well, that's it. Because we go through the hard part in the beginning when we help you get everything transferred to the trust. So again, when the first death hits, there's not a lot to do. Now, with this credit shelter trust, again, this is something optional. So for example, for myself and my husband, I talked about, I don't trust his future wife if I die and he gets remarried. So and this is what happens when you marry an estate planning attorney, right? So if I die first, my life insurance is going to go into that green box, that credit shelter trust. Everything else, the home, the savings, retirement, everything else goes to him, the survivor's trust. But my life insurance is going to go into that credit shelter trust. Now, he is the trustee of the trust. So he can manage the assets how he wants. He can invest the assets how he wants. But the difference is it can only be used for himself and my children and their descendants, right? So he couldn't use my life insurance to fund a new stepchild's college education. He can't name his new wife as the beneficiary of my life insurance, right? After I die. In fact, there's a prenup provision that says if he ever gets remarried, he's got to sign a prenup with his new wife, confirming that that's separate property in order to maintain access to that credit shelter trust for himself. He would receive all the income that's taxable, and that's for income tax reasons, because an individual's income tax rate is always going to be lower than that of a trust. And again, the principal is available at his discretion for himself, my children, their descendants, for their health, education, maintenance, and support. That's what that HEMS means. So health, pretty self-explanatory. Paying for college education, pretty self-explanatory. Maintenance, maintaining their standard of living. Support, paying a utility bill, putting gasoline in the car. So it's very available, but it also has that protection around it. So now let's talk about the second death. And if you're not married, just keep in mind we skip from the top part to the bottom part, right? We don't have that middle part there if you're not married. So on the second death, then, in this particular situation, this couple has three adult children. We have Sarah, Tommy, and Cindy. Sarah is the most responsible child, and so she's the one who's the trustee of the trust. Now, remember we talked about earlier how if you have assets titled solely in your name, so you don't have a trust, and if you're depending on your will to transfer those assets when you're gone, Sarah then would have to go through a full probate proceeding to get access to everything and distribute things. If there's a trust in place and everything is properly funded, all she needs is your trust document, your death certificate. She has instant access to the life insurance. She can immediately hire a realtor to sell your real estate. So she's going to pull everything together privately, quickly, pay your final debts and expenses, file your final tax returns, and then distribute again privately and quietly, no public record, to three separate trusts for herself and her siblings. Now, for Sarah, we're going to set up what we call a beneficiary directed trust for her. She's her own trustee of her share. She can do whatever she wants with the assets in her trust. But whatever she chooses to leave in the trust has a lifetime of both divorce and creditor protection for her. So if she ever gets divorced, you don't have to worry about any of the inheritance walking away in the hands of an ex-spouse. If she has health issues come up and she has to go bankrupt due to her own medical bills, she might lose everything else in bankruptcy court, but she won't lose the inheritance because it's got that bubble of protection around it. And so Tommy, he's a young adult, and so he's in his 20s. The brain isn't fully developed yet. I think there's a scientific study on that until you're closer to 30. And so for Tommy, we want to make sure that someone else is the trustee of his trust until he's 30, right? So let's say his sister Sarah is in charge, or maybe it's an aunt or an uncle or a professional trust company. We want someone there to help him make good life choices until he's a little bit older. If he's in college, of course, the trustee is going to pay for college tuition, help him with living expenses, but also help him work out a budget, right? You're 26, you don't have a job. Let's talk about that. I know you want the shiny red sports car, but today we're going to look at a used Honda. And so that's what that trustee is there, is to help himself, right, until he's older to make those decisions. And then Cindy has special needs and she's on SSI. And so we talked about how we can't leave money on a form to Cindy. We can't leave money outright to Cindy. So for her, she's going to have a special needs trust, right? This trust doesn't spring into existence until you're gone, right? But then Sarah, of course, is going to be the trustee for her sister Cindy. And then the assets in Cindy's trust will never disqualify her from the benefits that she's entitled to. They're non-countable assets. They're in a special needs trust. But what it is there for is everything that the government doesn't provide, right? So, for example, if you're on Medicaid and you have a tooth issue, then Medicaid will pay to have the tooth pulled, but it won't pay for any type of reconstruction. And so, of course, the trust is going to pay for that, pay for a new computer, pay for, like I said, summer camps or whatever she likes to do that the government doesn't pay for a cell phone, whatever her life looks like, whatever she needs, that's what that money is for, but it won't disqualify her from the benefits. So you can see why many people have trust. Now, I do want to clarify, I don't say that everybody needs a trust. Sometimes a will-based plan is going to be just fine with all the powers of attorney. But for many people, at least understanding the difference between wills and trusts is very important when we're talking about estate planning options. And then, let's see. For some reason, I can't go to the next slide. That is interesting. So, all right. So the next slide actually is a picture of Prince, which for some reason is not going there. And it says, the moral of the story is don't be like Prince. So Prince was a major star and a cultural influencer, but he was a human being. If you don't take care of it, you're leaving a mess to family or your loved ones. Prince didn't have anything in place when he died. No will, no trust. And the story has it, because I've researched this, his advisors, of course, told him that he needed to have an estate plan in place. He's Prince, and he told them, no, because that means if I put an estate plan in place, that I'm gonna die someday. Well, we're all gonna die someday, right? Like I said, whether you're 20 or 90. And with estate planning, it's not about you, right? It's about those who you leave behind to make sure that they're taken care of. All right, so with that, I am going to do my best to exit the screen share and then open it up for questions. Oh, there's my slide. Prince. All right, and there's my Q&A. Okay, I am going to stop sharing and go back to just me. All right, are there any questions?
So is it fair to say then that the ideal scenario, as I'm kind of listening to this for a child that maybe some of us have with special needs, is a third party special needs trust seems to be the one that allows the most flexibility, where the government cannot obtain that money in the end if they pass away. And then I think you said a revocable trust is Am I getting that right? Like I'm just trying to
So
kind of, yeah.
right, right. So the third party special needs trust, again, funded with someone's assets other than the individual with special needs, right? So it can never go directly to the individual, then to the trust. It has to go directly to the trust from someone else. It's third party. And yes, like we talked about, there's more flexibility there, and there's no payback provision. So again, on the death of the beneficiary with a third party trust, it's going to go back to the other designated beneficiaries and not to the state. And with a revocable trust, that third party special needs trust that we talked about for Cindy, it springs into action upon death. And so it's funded after death. Now, some families do choose to create a standalone special needs trust, a third party special needs trust for their child. That's something that might be advisable. For example, if you have grandparents who do want to name your child as a beneficiary of assets, but they know they can't name the child directly because you'll disqualify them from the benefits. And so some families, in addition to their own separate estate plan, choose to create that standalone trust so that other family members can leave money to that trust in their own estate plans should they choose to do so. So again, every circumstance is different, but yes, the third party definitely because it has much more flexibility and no payback provision.
Okay. And so then maybe I'm getting a little confused about the third party special needs trust and then the revocable trust. It sounds like they're two different things, or is the revocable part a part of the third party
So
special
the
needs trust?
right. So the third party special needs trust is part of the revocable living trust. So I'll switch that around on you.
Okay.
So the revocable living trust is the umbrella, right? That's what holds all of your assets during your lifetime, disability provisions, and then when you die, the revocable trust. Under the terms of the revocable trust, we create the third party special needs trust, which doesn't spring into action until you die.
Okay. Thank you.
Yeah.
I have a question. I am wondering, so I know in the beginning, you had spoke about making sure you name your beneficiaries. What if you don't have beneficiaries? And what if you like the one that you have has special needs?
Mhm.
What, I mean, what do people do in that scenario?
That's where you have to have an estate plan in place.
Okay.
There's really no, you just, you have to. It's kind of like if you have minor children, you can't name them as direct beneficiaries. If you have a child with special needs, you can't name that child as a beneficiary of anything. You must have some sort of a special needs trust set up, whether it's in a will or within a revocable living trust. But there's really no way around having some type of an estate plan in place because, like I said, you just can't accomplish the objectives with a name on a form.
Okay, so but by having an estate plan, that will take care of me not being able to name them as a beneficiary.
Correct.
Is it?
So let's say you have a
Okay.
will, right? Right. So let's say
Okay.
you have a will, because like I said, not everyone needs a trust. I totally understand that. So let's say you have a will, and in your will, we create a special needs trust for your child, right? So
Mhm.
then what you would do is you would name your estate as the beneficiary of any life insurance, retirement, knowing it's going to go through probate, but it's okay because again, I'd rather see it go through probate and then get to the trust that we create in the will, the special needs trust with all the protections.
Oh,
And so that's what we would do. Whereas if you have a revocable living trust-based plan in place, we name the trust as the beneficiary of everything, your revocable living trust. And
oh,
then it's all
okay.
right. So that's where we can never name the child as the direct beneficiary, but depending on the estate plan we have pieces to the puzzle, we name the trust or the estate.
Okay. Okay, that makes sense. Thank you.
I know it's confusing. Lots of pieces to the puzzle.
Hi, Dara.
If you have a grandparent that you tell about the trust,
Mhm.
but they don't do it and they instead directly name the beneficiary,
Yep.
what do
So,
you
and it
do?
happens. So, depending on the amount that your child is going to inherit, we would determine whether setting up a private first party special needs trust for your child is appropriate. And that would be if there are sufficient assets and you want to have independent, management and control over the investments in the account. If it's a larger amount, sometimes we do that. Or often what we do is we set up the WISPAC trust that I talked about earlier, or another pooled community options program. We set up the first, and this is a first party. It's always going to be a first party if the grandparent named these child with special needs as a direct beneficiary. So we can protect the assets, we can preserve the benefits, but there's that payback provision and there's no way around it. And we
Do
have
you
to act
need to
quickly.
do you need to have that first party one set up beforehand?
Nope. So you can set it up. We just have to very quickly set it up as a first
Okay.
party special needs trust so that your child doesn't get disqualified. That money has to go into that new trust ASAP. And so you can see how that's not ideal, right? It would be much better if there was some planning involved. And even if you did set up, so if you set up that third party special needs trust and then the grandparent names that trust as the beneficiary, if you had a standalone, again, much better. But there are some stopgap measures that we can use, like that the WISPAC trust to keep them qualified. But again, it's first party and there's a payback. And one other thing, in answer to that question, what some people are, they're trying to be clever and not have an estate plan pay for it. I get it. I understand. So what they'll do sometimes is they'll name like, okay, my sister would be the guardian for my child if something happened to me, and so I'm going to name my sister as the beneficiary, knowing that my sister is going to use the money to help my child with special needs, right? There are all sorts of pitfalls with that. Number one, your sister, of course, is under no legal obligation to do it. But regardless, what if she has health issues? She goes bankrupt due to medical bills. The bankruptcy court doesn't care why she has your life insurance proceeds. It's all going to be gone in bankruptcy court. Or if she gets divorced and, her husband was involved, maybe he's going to claim half. So that's not ideal either. So again, it's all about making sure the pieces to the puzzle fit together. And Laura, I think you had a question.
Yes, hi Dara.
Right.
So our we have a will and three children, two are adults and one is a minor with special needs. So do we need to and like our assets would just be divided between the three of them, right? That's what you do when that's what we did years ago. Just say, oh, our assets would be divided between the three of them. So should we set up a special needs trust within
Well,
that
yeah,
will or
absolutely. Yeah. Whether it's in a will or within a revocable living trust, you definitely need to establish a special needs trust for your child with special needs. Yep. And no way around it. It's one
and
way or
then
another. You've got to do it.
and then would they still get a portion into that trust?
Well, yeah. So you will designate. So if you said you had three kids, right?
Yes.
Yeah, and you want three, there's not many parents still distribute three equal shares. It's just that one share is going to go to one adult child, the other third is going to go to the other, and the third that's set aside for your child with special needs is going to be directed to the special needs trust that's set up in your will or living trust.
Okay. Thank you.
Of course.
Oh, one other
Yeah.
question. What's an approximate cost to set up like a revocable living
Sure.
trust?
Sure. So the disadvantage of a trust is it is more expensive. There's no question. Because I have people ask me, well, why doesn't everyone have a trust? It's so much better. Well, it is so much better, but it's also expensive. And I like to be very upfront about fees. And so, for example, for a married couple, what a revocable living trust-based plan includes is everything that we talked about from the top to the bottom. And obviously, I threw out, generalities about this hypothetical couple, but it's very specific to you and your family, a whole list of questions to make sure it's exactly what you want, including the special needs trust, the divorce creditor protection for the other kids. Some people have charitable distributions. Some people have pets that we want to provide for. Furry family is important also. So it's all taken care of. I build the trust for you, and then we also help you put everything into the trust. So we have you fill out a client asset booklet, and then we do all the paperwork to help you make sure it's all in there. Because again, if it's not all in the trust, it doesn't work and it doesn't avoid probate, right? Also, all the other pieces to the puzzle are included. So the financial powers of attorney, because you want to make sure someone can sign tax returns, manage social security payments, credit cards, utilities, pension plans, anything outside the trust. We want to update all of your healthcare documents. We want that personal property memorandum. We want the funeral planning. So all the pieces to the puzzle are included in the plan. I don't charge my trust clients for phone calls to my office with questions about your estate plan, and that's a lifetime benefit. So if you're selling real estate and the title company needs some documents, just send them to my office. My paralegal will forward it over. You won't get a bill from me for that. If you're buying a new car or opening a new account, you can't remember what you're supposed to do, or you get a new life insurance policy, you can always call my office. We'll get you on track. We actually prefer that you call because we can help you fix it later, but it's easier for us if we just help you make sure everything continues to stay titled properly as the years go by. Also, every few years, I like to see my clients for a review just to check in, right? Make sure everyone's still in the right seat on the bus, check in, ask them, have you opened new accounts? Is everything still in the trust? I provide a free appointment to the spouse at the time of the first death if you're married, and then also to your successor trustee on the second death. So my package price for a married revocable living trust-based plan is $4,500. Plus, there's a $35 recording fee for each deed we need to record. That's just what the county charges. And an unmarried person, the revocable living trust-based plan is $2,800 plus any recording fees for real estate. And that's compared to a will-based plan, which again is very comprehensive. It includes all the pieces to the puzzle. We build the special needs trust within the will for your child. It's very comprehensive. It just doesn't avoid probate in the end, and it can't provide things like divorce and creditor protection for other children. But it's still very comprehensive, and it will protect your child with special needs. For a married couple, that plan is $1,600. For an unmarried person, it's $900. And guys, I know that these fees are a lot. I get it. I do assure you that my fees are very reasonable based on what other attorneys are charging in the area. But it's expensive, right? And I totally get it. And that's where, Janice, for, if it's something that's not that you can't afford, I know that Janice, that's what she does. She has options that are available for families. This is her whole mission here, is to help people get estate plans in place one way or the other.
Thank you so much.
Yeah, of course.
And I'll just kind of jump in there. Again, it's Janice with Morgan's Caring Connection. I'll just kind of jump in there and let people know that, when we established up our estate plan, yes, it was very expensive. When you have children with special needs or dependents with special needs, we're always spending money on things to protect them, to protect us, that quote unquote normal families don't have to. But I will tell you that if you take that dollar amount and you divide it by however many years you're alive, it comes out to be very, very little money. And I will just say that there's nothing that provides more peace of mind than that document. So that's why we started Morgan's Caring Connection, to be able to provide people with the peace of mind. So if anybody that has joined us on this webinar is afraid that they can't afford it, that's what we're here for. That's what Dara is referring to. You can apply for a grant, and we fund anywhere from nothing up to 100%. And people have come to me and asked me, will you still help us connect with an attorney if we don't need funding? And the answer is absolutely, because we want to make sure that you talk to someone that you can trust, that understands special needs, whether it's an estate planning attorney, financial advisor, and many other vetted professionals on our website. So just so that if anybody has any questions about that, you can always call me first. If you want to work with Dara directly, you can call her directly. If you want to work through me and I can support you through it and connect you with her, that's fine too. Everybody has to find what works best for them. I just find that a lot of families don't know where to start and who to trust. And this is a great place to do it, is with us at MCC. If anybody does anybody else have any last minute questions before we wrap up here? If you set this.
I had a question. I want to clarify one thing that you mentioned about that, the third option in the trust, like from the special needs trust that could be pooled.
Oh, the pooled option. Yeah. Like the WISPACT option that I was talking about.
Yes, thank you. That
Yeah.
WISPACT was
Yeah.
the choice. So when you say a third party, that the money has to come from a third party,
Mhm.
that applies to that one as well, or that can be either?
It can be either. So again, WISPACT has two, and I know there are, it's not just WISPACT, there are other organizations who do something similar. It's just I'm most familiar with WISPACT. But yeah, either one. And so WISPACT, when you establish the trust, you'll determine, are these the assets of the individual with disabilities? So it's a first party, or is this someone else contributing to the trust? And then it's a third party without the payback provision. So within the pooled community trust program, it's going to be first or third. Yep.
Okay. So when the money's coming from a third party, I guess something that I was wondering is if our adult son pays bills and we like, how do I say this? Like those go into our account to help contribute
Right.
to house bills, but can we
Right.
put money from our account into his trust?
Yep, you absolutely, and then it would be third party. And
Yeah.
I understand, of course, parent, you have to keep him under that $2,000 asset limit. Of course, that yeah, I get it. That all the time. But yeah, then once you so basically he pays you rent, it goes into your account, and then you could turn around and put that money into a third party WISPAC trust. And the thing about the pooled community trusts, the WISPAC trusts, is that provided when you open the account, the amount that goes in is less than I think it's 75,000. That doesn't even cost anything because the attorney's fees, and you have to find an attorney who's approved on the WISPACT attorney list. And of course, I am on there. But the WISPACT program pays my fees, so it doesn't actually cost anything to set up a WISPACT trust, provided it's less than 75,000-ish.
Oh, okay.
Yeah.
And then there was one other question. If you set this up in Wisconsin, but then move out of state in the future, are there any issues?
Yeah, nope. So I have plenty of clients who have moved around over the years, and we have our reviews by Zoom, right? When they're sitting in Arizona where it's nice and sunny and it's 20 degrees here. Um, and so no, so we have laws of reciprocity across the country, which means if, the trust was valid when it was set up in Wisconsin, or a will for that matter, no problem. It's going to be valid in any state. Every single state recognizes a revocable living trust. So you don't have to redo everything when you move to a different state unless you choose to do that. But yep, plenty of people have a Wisconsin trust and they live in Florida or Arizona or Texas or wherever. No problem.
Somebody said, can't remember what you said happens at 50,000.
So what happens is if you die with assets that are titled solely in your name with no direct beneficiary, and if the total value of those assets exceeds $50,000, then your estate has to go through the probate process that we talked about. If it's less than 50,000 total, there are abbreviated procedures like a small estate affidavit that we can use instead, but it doesn't provide any protection for a child with special needs, for example, either.
Any other questions? All right, I'm going to be mindful of the time. I did put a link in the chat, two of them. One is a link to our actual webpage that lists all of our upcoming webinars, and the other one is the next one that we're doing with Dara in April that she mentioned previously on April 28th for guardianship, and we will continue to send these out to our local foreign nonprofits that partner with families like ours. And like I said, you can always come to us directly to our website. Oh, I think there was one more. Oh, no, we're good. Okay, so on that note, we are recording it. I apologize, it was late, still learning Zoom. And I will be posting that on YouTube and on our website. So that way, if you have any questions that we reviewed and you want to go back and double check what Dara said, you may feel free to do that. Thank you all very much for your time. Have a wonderful evening, and we appreciate you.